I want to talk to you today about bail and bond. What's the difference between those? And how much do I have to pay to get a loved one out of jail? And do I get my money back if the person's found guilty or not guilty? Stick around, we'll talk about it right now. Amount that the court sets for a defendant's pretrial release. And what that means is you've got a person in custody, they've been charged with a crime, and there's going to be a number of court dates before that person actually has a plea or a trial. And so this is money that's being put aside with the clerk to ensure that that person always comes to court. There are a number of factors in Tennessee that relate to bail and bond, and they are factors like a person's length in the community, their mental and emotional health. People are going to be looking where they work or not. One of the worst factors for defendants is really the likelihood of conviction. And that's always a frustrating one for defense attorneys because it's like the prosecutor gets up and they read the charges, and it's like you have to get in a time machine and decide, well, is this person going to get convicted in the future or not? And of course, at that time, it's not appropriate for us to really lay into why we disagree with the charges. But that's one of the biggest factors that the court relies on. And even though that's frustrating, it makes sense because obviously a person charged with a really serious crime, and if that person's facing a lot of jail time, they're less likely to come to court. So that is a legitimate factor, but it's certainly frustrating because it's almost like if a defendant gets charged with something serious enough, they get a double whammy because they get a crappy bond too. But bond is the actual oath between a bail bondsman or family, guarantors, creditors who are signing on and saying, hey, you know what? I will pay this full amount if this defendant doesn't come to court. A lot of times you've heard about people saying, I need 6 signatures. If you're signing on a person's bond, what you're saying is, I'm on the hook financially if this person doesn't come to court. But that's the difference between bail and bond. Bail is the amount set by the court. Bond is the actual oath, usually in the form of money, to say that we will make good on this if the defendant doesn't show up. So moving from there, let's talk about an imaginary bond. A loved one has a bond of $100,000. Let's just keep the math easy. So in most cases, people don't have $100,000. What they need to do is they need to go through a bail bondsman. And a bail bondsman will take somewhere between 6.5% to 10%. They will wire the money to the court. And as long as that defendant always shows up to court, they will be released from that at the end of the case, whether that's a plea or a trial. However, if the defendant does not show up to court, the clerk can say, you're going to pay the other 90% of this. And then, of course, they're going to turn to the creditors and they're going to say, if we have to pay this, you have to pay this. And of course, they'll try and hire a bounty hunter to grab that person before a certain amount of time, something like 90 days, before they're finally on the hook financially with the court. But that's a corporate bond, and that's through a bonding company. Now, people ask me all the time, do I get that money back? No, if you're paying like the 6.5%, the 10%, if we're using our example of $100,000, you'd pay $6,500, you'd pay $10,000 plus some administrative fees. That's a contract between you and that company. And it really has nothing to do with whether the defendant is found guilty or not guilty, whether they plea, whether the case is dismissed. The bail bonding company is going to say, hey, we took a chance on this defendant. It could have been that they didn't show up and we had to go find them. So we're glad that they showed up for all their court dates, but there's no reimbursement. The contract is merely concluded. That's what's called a corporate bond. Moving from there, we have another one called a cash bond. This might be if a defendant's bond is something like $5,000. And the family says, you know what, let's just, instead of giving like 10% of that or $500 to a bail bondsman, let's just go ahead and pay $5,000, paying it in full to the clerk's office. Now, you can get that money back, but if you think about it, you've been giving them an interest-free loan. Maybe a case has been pending for 2 years, so you may not come out better. Another problem with cash bonds is the clerk may decide to decrease the amount by court costs, fines. They may take any charges out of the cash bond. You may not get the full amount back that you paid. In some cases, you've heard of something called a property bond. Now, property bonds are more rare than you might think. I know it seems like, well, a lot of people don't have a lot of cash, but they maybe have a car or a house. So, that might be your first instinct, is to think that they would put that up and sort of put a lien on a property. The reason property bonds are not as common as you might imagine is because you have to actually have the equity in the house. If you have a $200,000 house, but you're making mortgage payments on it, it's really owned by the bank, not really owned by you. And the clerk's office doesn't want to mess with property that somebody else has an encumbrance on. So you would really have to own any property in full. Now, at least in Tennessee, property bonds are only given like half value. So if you wanted to post a bond, a property bond, on a defendant who had a $100,000 bond, then you would have to have $200,000 in equity paid in full. Now, if you do that with the clerk, you do get all that money back, or you're not really even transferring money. It's just that there's a lien on your house so that you can't sell it while you're using it as collateral. And then that lien is removed at the conclusion of the case. So it's sort of like using your house as a line of credit. The problem here is, of course, if the defendant takes off to another country, you will become homeless. So property bonds are not usually the right move. I want to move now to something that's really all over the state of Tennessee, but it's certainly very prevalent in Shelby County. And that's something called a source hearing. When a defendant has a bond that's $100,000 or more, the court can have a special hearing and require the people posting the bond to show the source of that money. So, for example, let's go with our example. A defendant has a $100,000 bond, and 5 people from the family are going to post $6,500 or $10,000 with a bail bondsman. Well, the court's going to say, before I allow them to even post that bond, I want these contributors, these family members, loved ones, employers, whoever's putting money in on this, I want them to come to court, and I want them to produce financial paperwork. I want to see where this money's coming from. And that financial paperwork should add up to the same amount that's being contributed toward the bond. So, for example, if they're paying $6,500, 6.5% on a $100,000 loan, they can't have paperwork that adds up to $3,000. Where's the rest of this money? Now, source hearings can be pretty intimidating if you have a drug case or if you have a theft case, because the court is probably most suspicious in those, because those are financial crimes. The court wants to make sure that a person didn't just go steal $12,000 from their employer or make that selling drugs and then turn around and use that same exact money to get out of jail while the case is pending. The ironic thing about source hearings is that it's probably easier to do a source hearing on a murder or a rape, probably more serious crimes, but they're just not crimes that result in receiving assets or proceeds. So in some cases, the prosecutor might say, I've looked at your financial paperwork, it looks fine. You may not get a lot of pushback. In other cases, the court may really go through people's financial statements with a fine-tooth comb. But that's something that is required if the bond is $100,000 or more. Many times, a bond is so high that the family says, look, we can't pay it where it's at. Let's try and have a bond and a source hearing. So I want to put proof on and say, Judge, this bond's too high. Maybe it's $150,000 right now. Let's try and get it down to $75,000, and then we'll no longer have the source hearing requirement. Now, that can work in some cases, although I have found that judges I always seem to find that sweet spot of 100,000 because they like to know where this money's coming from. You also have to be careful what you're saying on the stand because it may be that you're revealing facts about the case. Oh, you're living at this address and the crime happened at this address. And this is the place that you say that you can stay while the case is pending. But that's also your fact witness in this case. So even though bond and source hearings are not really about the details of the case itself, there is going to be a certain amount of personal information that has to be revealed in those cases to try and get the defendant out of custody. I recently had a case where a bond was set at an amount the defendant could pay, and the defendant said, I just want to come in on the source hearing. I just want to come in and show where these proceeds came from. But the court actually said, no, I want to have a bond hearing too. And that case had to go up to the Court of Criminal Appeals. And the Court of Criminal Appeals said, if a defendant is just asking for a source hearing, there's no written motions to have it go up or to have it go down, then that person can just put on proof about the financial situation. Where is this money coming from that's being used to post the bond? But I want to caution you, a lot of people say, well, let's just try to get the bond down lower and then we'll do the source hearing. Or maybe we won't have to do the source hearing because it goes under 100,000. But anytime you're asking it for it to go down, it can also go up. So if the court doesn't like these factors that they are to rely on, if your defendant has a number of failures to appear, has not done well on probation, has an extensive criminal record, has been known to be sort of a flight risk, then that bond could go up to $1 million. And there's really nothing that the defendant can do about it because the defendant asked the court to examine that. If you have the money to do the source hearing only, then do the source hearing only. If the bond is $100,000 and you can get that $6,500, you can get that $10,000 together, then I would discourage you from asking your attorney, let's see if we can get it down to 50. Because if it can go down, it can go up. In most cases, you only want to have the source hearing when you have the money. Because when you try and save, the prosecutor can put on evidence, all of a sudden it's not looking good, and the court goes up to an amount that you can't make the bond anymore. And it doesn't even matter that the source of the funds that you're going to use have been found to be legitimate because it's just not 10% anymore. So the bondsman says, I'm not going to sit on a $500,000 bond with your $6,500. If you have any questions about this, please leave them in the comments. Let me know. Is there anything about this video that was confusing? Anything I could do to explain? I'd love to read those comments. I review them regularly. And if this provided value for you, I would love for you to subscribe, like, and I look forward to seeing you next time. Thank you.